Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about unreasonable delays to trial. Cases that should have gone to the Supreme Court of Canada, but didn't. Marco Milan was facing charges related to the conspiracy to import narcotics into Canada. His trial took place at a very unusual time in Canadian law. The charges predated the Supreme Court of Canada's decision in Jordan, but his trial postdated the Supreme Court of Canada's decision in Jordan. This is what is known as a transitional case. In transitional cases, the framework that applies for determining whether or not the case was tried within a reasonable time is different than the traditional Jordan analysis. And Mr. Milan argued that the judge applied that framework improperly in finding that his right to be tried within a reasonable time was not appropriate. What the judge did, effectively, was focus on the pre-Jordan delay as a separate issue from the post-Jordan delay, which the judge found was below the 30-month ceiling. And ultimately, Mr. Milan ended up convicted. He appealed, lost his appeal, and sought leave to the Supreme Court of Canada, which was denied. And this case raises very important issues about the calculation of delay. It's quite surprising that there are cases still in the system not affected by the Jordan decision that are dealing with arguments about delay. And yet, nevertheless, Mr. Milan found himself in that position. And by applying the transitional provisions, by essentially siloing off post-Jordan delay and not considering it, this raises a very problematic issue about whether or not the actual Section 11B right, which should be considered holistically, in that it's not the time to a trial before Jordan and the time to a trial after Jordan that are considered separately, but instead the holistic protections for the person's charter-protected right to be tried within a reasonable time. And if the Supreme Court of Canada is not going to hear this case, then it raises significant problems about how we interpret other situations where the law changes in the middle of a proceeding. Ultimately, what happens in these circumstances is that people don't have certainty about which law is going to be applied. Essentially, it's an implicit endorsement of the idea that you can hive off and silo two separate periods in a continuous and essentially continual transaction of a proceeding and treat persons' protected charter rights differently depending on when the conduct fell on that point of time. And that can't be the interpretation that's given to the Charter. While, of course, our Constitution is a living tree and evolves and changes over time, that doesn't mean that constitutional guarantees and the values they reflect change in the midst of a single proceeding. And this was essentially the point that Mr. Milan was making. And I think the Supreme Court of Canada really missed the opportunity to see the way that the analysis that was done in this case watered down those charter protections, not just on Section 11 of the Charter, but on all of the sections of the Charter that apply to criminal trials that are consistently being interpreted and changed and nuanced by the Supreme Court of Canada. Hopefully it doesn't take another case involving an individual who is charged with an offense that has their charter rights change in their interpretation over the course of the time between when they were charged and ultimately when they go before trial, for the Supreme Court of Canada to have the opportunity to address this issue. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazenbull Creative for putting together these videos. Please like, subscribe, and share with your friends.